Hi, we're here today with Senior Judge Norman Ackerman of the Philadelphia Court of Common Pleas in the First Judicial District of Pennsylvania. Good day, Judge Ackerman, and thank you again for helping us and coming here today and participating.
Well, not at all, Len, and thank you for the kind invitation to be here.
Well, sure, and we've known each other for quite some time, and I'm really happy to be able to interview you finally.
And I hope we continue to know each other for some time hereafter.
Thanks very much. Right back to you. Judge, can we start out with a little bit about your background?
Well, let me start out by saying this is my 51st year in practicing law here in the Commonwealth of Pennsylvania, as well as being a judge in the First Judicial District. Something I'm very proud of.
It's incredible.
But it all started, obviously, I was born and raised in the city of Philadelphia.
Mm-hmm.
I matriculated after Olney High School. I went to the University of Pennsylvania and graduated from the Wharton School in 1957 with a Bachelor of Science in Economics. Then went over to Temple Law School and graduated there in 1960 with a Bachelor of Laws degree, which later was converted into a Juris Doctor degree.
Okay.
I took the July 1960 bars and passed the bars and was admitted here in Philadelphia County, the Court of Common Pleas, as well as the Superior Court of Pennsylvania in December 1960, and the Supreme Court of Pennsylvania in January of 1961. I thereafter practiced law here in Philadelphia for some 27 and a half years, and I felt very grateful because my practice, I believe, was a well-rounded, diverse practice, both civil and criminal courts. I also, at that particular time early on, I was appointed by Governor Scranton and Governor Schaefer to the as Assistant Attorney Generals in the Commonwealth of Pennsylvania and Special Assistant Attorney General when I represented the Department of Highways here in Philadelphia County, doing their eminent domain land acquisition work.
All right.
My other position with the department was with the Department of State, in which I represented the Professional Licensing Board. So I developed some sort of expertise, not only in land acquisition, eminent domain work, but also in administrative agency work.
An incredible amount of experience already in a fairly short amount of time in your practice
And
of law.
I feel very grateful that I was given this opportunity.
Yeah.
And the experiences didn't stop at that. When I left the Attorney General's office, I was appointed as first assistant clerk to the Orphans Court. So I developed the clerk of the Orphans Court, obviously, was the Register of Wills.
Yeah.
So I was the first assistant and developed an expertise in estate practice. After that was concluded, I was appointed Deputy City Commissioner. I was counsel to the Republican City Commissioner, John Kane,
Yeah.
and was there about 8 years. And after that the term ended, or during that particular term, I was made a federally approved bankruptcy trustee. And I did bankruptcy work down in federal court some 11 or 12 years. So I felt very fortunate that I was able to have this diverse practice. In my practice, I did criminal work, as I said, I did civil work, I was solicitor to Society Hill Saving Loans Association. I did collection work with Carte Blanche here in Philadelphia for Philadelphia Accounts. And what else did I do? I represented a small oil company that was located in South Philadelphia and a meat distributing business. So I was given the opportunity to do plaintiff's work, defense work, criminal work, and administrative agency work, in which I had many reported decisions, and as well as land acquisition work for the Department then of Highways, which now is known as the Department of Transportation.
Yeah.
In 1988, I was appointed by Governor Casey to the Court of Common Pleas in Philadelphia County. For an unexpired term in 1990, I was elected for a full term, and in 2000, I was retained for another 10-year period. I served as a trial judge, mostly after 3.5 years in the criminal courts, the balance of the time here in the civil courts of Philadelphia County, and until my 70th birthday, which was in 2005, And since that time, this is starting my 7th year as senior judge.
Oh,
I am married. I'm married for 49 years. My wife's name is Gita,
Yes.
Geita Ackerman. I have 2 daughters, I have 4 granddaughters, and 1 grandson. It's been a long haul, and I hope it continues.
Congratulations.
Thank you very much.
I don't know how you would have had time to do anything
And I'm still
else.
smiling.
Yeah. Well, you're a great guy.
Thank you.
With a cool personality too, I think. So was, when you were appointed a judge, was that just something that was coming down the pike and the governor said, you know, I like this guy, or was it something that you had your eye on, the judgeship,
Well,
to go along with
very-
everything else?
Very early on in my career, after I passed the bar, we moved up from Feltonville.
Hmm.
The family and I moved to the Northeast. I became active as a Republican committeeman in Northeast Philadelphia.
Right, okay.
And it was an ideal situation. I got so much love out of what I was doing. I was able to help people. And you know, I was wet behind the ears, so to speak,
Yeah.
in the sense that I tried to involve myself in neighborhood disputes. And that's the toughest thing to involve yourself in,
Yeah.
because you can lose both neighbors if you can't work it out. Well, fortunately, I was able to work out problems, and I said to myself, it must be this is great. I just hope one day I'm given the opportunity
Yeah.
to be on the bench, end my career on the bench.
How
And
about
thank
that?
goodness I was given that opportunity by
Yeah.
Governor Casey.
That's great, that's great. And we're happy that he gave you that opportunity too.
It was something that just came up. I mean, as I indicated to you off camera, I was one of the 5 finalists for Judge Goldhaber's bankruptcy court position
Right.
when he stepped down, and I'm not sure if he stepped down because of health now or what the reasons were, and it was a little disappointing to me. But you know, things worked out well.
Yeah.
The Court of Common Pleas Trial Division is the best judgeship, in my judgment, that anyone could have.
Worked out well for
And
us.
I thank Governor Casey for the opportunity to be here. And if you ask me the question, that's one of my proud moments, because I was originally nominated by Governor Casey in 1987, and I chose not to run at that time.
Oh, I didn't know.
Yes, there was things that I had to do. I just didn't feel it was the right time to
Mhm.
run. But 1988 rolled around, I said to myself, if I'm given the opportunity, I better take it, because you never know when it's going to come present itself again.
Right.
And some of my Democratic friends came to me and said, Governor Casey's mad at you. He didn't run in '87. He may not appoint you. Well, he did.
Good.
He nominated me again, and that was a proud moment, because here was a Democratic governor
Right.
who nominated twice a former Republican board leader. So that was a very proud moment to me.
Congratulations. And I can see why that would be a proud moment to you. Have you seen a lot of changes from the way law had been practiced, either in the courtroom or otherwise?
Let me give you a short dissertation. It's changed in 2 ways.
Sure.
Maybe more, but that I can specifically recall.
Okay.
Your word was always your bond when I started Senate. Even before I became a judge, when I used to go visit, my dad was in the real estate business here in Philadelphia.
Mhm.
And I saw him close deals on Broad Street with a shake of a hand. Never needed confirming letters. And it was marvelous. It was a marvelous way to do business.
Right.
Well, lo and behold, when I first was admitted to the bar, I was sent over to try a case. It was a loser, it was a typical loser, what you send young attorneys to handle. And I remember Judge Boyle, his name may not mean anything to you, but he called my case for trial, and the other side wasn't there. And Judge Boyle said, well, Mr. Ackerman, what do you want to do? I'll take your case, we'll try it ex parte if you want. I said to Judge Boyle, can you pass it? I'm going to call counsel. He passed my case, I called counsel, and he said he'll be there. He was delayed, he'll get there.
Mm.
Well, 10, 11, 12 o'clock ran around. Judge Boyle calls me up again. Counsel's not here. What's your intention, counselor? I said, Judge, can we pass it until after lunch? I spoke with counsel. He said he was tied up. He's going to get here.
Yeah.
Judge Boyle said, fine. I waited till 12:30. Counsel never appeared. So I went back to my law office.
Yeah.
I spoke then to Joe Sharfson. He wasn't my preceptor, but he was in that office. Joe Sharfson was former city solicitor. He had wonderful clients, caliber clients. He represented the Roosevelt family.
Oh, yeah.
And he represented Gloria Swanson, if that name means anything.
Sure.
And he said, well, what happened over in court? And I gave him the history. And he looked at me and he says, what are you doing here? He said, you gave your word that you'll wait for counsel. Now you get back to that courtroom and wait until he arrives. Your word is your bond. And that's the way the practice was. Is
Yeah.
it that way today? Well, you can draw your own conclusions from your own
I
experiences.
don't think so.
And I don't think it is either. Also, no dress down days. When you appeared in court, you were wearing a dark suit. Not sport clothes, you had to wear a dark suit. And today, of course, we have dress down days. Sometimes lawyers find their way into my courtroom apologetic. They don't have a jacket. And I said, this is the last time you'll appear in front of me without a jacket.
Yeah.
You can have dress down days, but keep a jacket in your office in the event a problem arises such as this.
Yeah. Just
So-
in case.
Well, that's,
Right.
but they're the two most important changes, I think. There's probably others.
Yeah.
Of course, when you practice law in those days, generally, other than criminal courts, you didn't do much work in the summertime. The judges' calendars were closed.
Right. There weren't many.
No, Orphans
courtrooms
Court was
open.
closed.
Right.
The Orphans Court judges handled the criminal court matters at that time. So it was I believe it was less stress on the judges in the 60s and the 70s.
I
than there are
imagine
now.
until September came along.
That's right. That's right.
I do recall.
Of course, they
those.
had their own calendar of cases also in those
Yeah,
days.
that's right. Yeah, they kept their own calendars.
Mm-hmm.
Do you think that you've made particular contribution? Now, I know, again, I'm going over a career that was filled with sub-careers, if you will, as a deputy commissioner and as an assistant attorney general and as a bankruptcy trustee and, other capacities. But is there something that you can point to that you felt that you've given to the practice of law that
Well, I think that the community work is very important. No matter whether you're a Republican or a Democrat, a city committee, a ward leader or a committeeman, it's public service. And basically what you're doing is giving your time to assist those in the community. And I'm very proud that I was able to do that and develop a practice at the same time. But there are a few things that I'd like to bring to your attention, and I think it's it's very important. Not only have I served 23 now, it's 23 and a half years on the bench, but I think it'll be 24 years in June, and I think approximately 1/3 of that time has been in leadership capacities. I was team leader at Day Forward program.
I remember that.
And my proudest part of leadership deals with Complex Litigation Center. When I was appointed the courting judge
Sure.
at Complex Litigation Center for over 3 years, that was a proud moment because, I know you know, but I don't
Yes.
know how many people realize that this was a model for all the states. It was developed where judges had expertise in this area. Lawyers love to come here. They love to come here to practice for a number of reasons. Number one, they knew their case would be tried by a judge who was familiar with complex matters.
Okay.
Two, when I first became coordinating judge, cases were coming up probably about 3 years after they were filed, which was a little outside what the American Bar Association wanted. They gave a two-year period. We eventually got to the 2-year period
Yeah, I
by the
know.
time
Yeah.
I became a senior judge. But the attorneys loved to come here because they knew just about when their cases would come up. They could advise their clients how long it would take for their case to come up.
Right.
And they could go to bed knowing that there wouldn't be any cancellation fees for their expert witnesses, because when cases were scheduled, cases were tried. And so the attorneys from all over the country wanted to come to Philadelphia.
They could have confidence in the system.
For that reason.
Yeah.
That's why I say it was a model for the other states. But notwithstanding the fact that our complex litigation center was known throughout the United States, there were individuals who took cracks at us and said we had cases, and they're even saying this today, I think, that don't belong here.
Mhm.
They should be tried in other jurisdictions. Now, I don't know if they understand the common law of the Commonwealth of Pennsylvania, but our law is clear, and I think our Superior Court has said so,
Yes.
that the choice of venue of a litigant is to be given great and heavy weight. And we do that in the city of in Pennsylvania.
Yes.
And our Superior Court said that that weight should not, that choice of venue should not be precluded unless there's another state, another venue which has jurisdiction, which is available to try the case.
Mm.
And it shouldn't be precluded unless there are heavy reasons, weighty reasons to do so.
Mm.
So we don't dismiss a case because someone from New Mexico comes into our courtroom and try a case. You don't do it
Yeah.
sui sponte. And we require counsel to submit a motion to dismiss, or file a motion to dismiss.
Mhm.
Well, it was done in the PPA Complex Litigation Center. PPA was a mass tort program and involved an ingredient that Bayer put in their cold medication,
Yeah.
Alka-Seltzer Plus, and allegedly it caused strokes in individuals who were taking it. And many of our cases in the PPA program were brought by out-of-state litigants.
Mhm.
Now, a motion to dismiss was filed. Otherwise, I wouldn't sui sponte say you cannot utilize our courtroom.
Right.
And after hearing, much to the chagrin of plaintiff's bar, I dismissed those cases. And I said that there were weighty reasons to do so and to preclude the choice of forum that the plaintiff has made. Well, there were some, the attorneys representing the plaintiffs never thought I'd be sustained. I had colleagues who believed I was wrong,
Yeah.
but the Superior Court agreed with me
Uh-huh.
and started out by saying what I just said, that the choice of venue of a plaintiff must be given great weight, and it shouldn't be precluded unless there are weighty reasons for doing so.
Mhm.
In my cases, there were. The Superior Court agreed with me in a lengthy opinion. Appeal was taken by a la carte to Supreme Court. They denied a la carte.
Uh-huh.
So my decisions still represent the law of the land.
Right.
So
And-
that I'm very proud of that, and I'm very proud of the Complex Litigation Center. And as a senior judge, I'm still working there.
Good for you. And you know what? That's only the right thing, to tell you the truth. It's good for you, and it's
And yet, you'll
good
see,
for us.
you see, Len, even today, they're saying it's the practice in Pennsylvania, the Complex Litigation Center. I hate to use the word, but it's, what did they say? It's a hellhole.
Mm.
And why are they saying that? They're saying it because we're taking cases that they say don't belong here. And I
Yeah.
say they do belong here. People have a right to go into a forum of their choice. But if in the right type of case, if the plaintiffs are residing outside of the state, if the ingestion took place outside of the state, if the alleged injury occurred outside of the state, if all the fact witnesses are from outside of the state, well, then that case does not belong in Pennsylvania.
Right.
If you have those weighty reasons to dismiss it.
Yeah.
But but you have to take it on a case-by-case basis.
Sure. Well, I know that you accomplish great things in terms of volume of cases also up there, and it's just impressive. It's very impressive.
Thank you, and we have a lot of good judges doing that work today.
Yeah, that's great. Is there any advice that you might give to a new judge starting out today?
Well, it may very well be basic, but I would tell a judge, number one, be prompt.
Mm.
And why do I say that? Because generally, we tell the jury to be present at 9 o'clock. And I know I advise the jury, and generally, I want the jury to have a good time in court. I don't want them to think that they're there because of the burden of citizenship, that they have to be engaged in jury duty.
Yeah.
So I always tell them, I said, number one, I'm going to try expeditiously to get rid of this case as quickly as possible, because I know you have to go back and to take care of your own personal business and your way of life, which you're given up to be part of this jury process. And I said, but I want you here at 9 o'clock. It doesn't mean, and I want you to bring your coffee and relax. You very well may not be called out until 9:30, quarter to 10. If that happens, that's because while we're both judges in the jury trial, we have different responsibilities and functions. So I very well may have to go over motions, legal matters with counsel in order to determine whether certain evidence can be admitted for your consideration. So if you're not called out promptly by 9:30, I guarantee you'll be called out at least by quarter to 10. But you know that I'm trying to take care of my end of the bargain, of the deal, and to review all motions that are filed. So it's important, if you're going to have counsel in there at 9:15 with their witnesses, if you're going to have the jury in there at 9:15, at 9 o'clock, be present at 9:15 so you can call the jury out expeditiously. And that's why I say the judges should be prompt. And I'm in my courtroom generally quarter after 9 at the latest every day. I start anywhere between 9:30 and 10, depending upon whether there's motions, and the jury understands that. In addition to that, know the law. Don't. I know sometimes it's difficult because you get a case at the last moment, the day before, but take a look at the file that you have. If you think that there's something you have to know, research before you go in and call that case for trial. If there's motions in limine, go over the motions. Show the attorneys that you know as much about the law as they do, and they've lived with the case. Now, the important thing in that regard is that this will assist you in a lot of ways. It'll assist you in not having unnecessary conferences, sidebar conferences with counsel, because they're going to know that they can't pull the wool over your eyes in regard to the law of the Commonwealth of Pennsylvania. But it also may assist you in having that case settled and not necessarily go to verdict.
Right.
The third thing that I would say to counsel is develop a reputation of fairness and impartiality to both plaintiffs and defendants. And I try to do that every jury trial that I have. When I tell the jury, and I have a statute of Lady Justice on the bar of my court, and I tell her that every portion of Lady Justice has meaning and represents what goes forward here in the free world and the Commonwealth of Pennsylvania. And I say Lady Justice is blindfolded because every person, no matter what the race, ethnic background, or religion of that person is, no matter whether that person is a small person such as us, or a larger group practicing as a partnership, or even the largest body known to the law, corporation, everyone has a right to come in front of this jury, in this courtroom, and receive equal justice under our law.
Very good.
And I try to maintain that. Now, why is it important? It's important because not every trial has to be a jury trial. It could be a judge trial. And if you develop that reputation of fairness and impartiality, lawyers are going to want to try in front of you. And as a bench trial judge. Also, develop a system of courtroom procedures. Now, what I do is I have the procedures, the important procedures, on the desk of the litigants. So when they come in, they can say Judge Ackerman's courtroom procedures. What does this do? Well, one of my procedures is that you treat all witnesses properly. Treat them. Don't be argumentative with witnesses. Treat them as you would in your normal everyday discussions with the fellow member of the bar. Be cordial. And why is that? Because I want the jury to enjoy being here in Judge Ackerman's courtroom as a jury of their peers, of the peers of the litigant. I want them to get insight as to how our system of justice runs. And if they do, and if they have an enjoyable time, it'd be easier to have jury. People won't be trying to get out of jury duty.
Right.
So if counsel knows this, and don't argue in front of the jury, if ask the court for a sidebar conference, and if the trial goes as anticipated, and I tell the jury that part of my duties, responsibilities, and that's why we have black robes, that's why Lady Justice has a sword at her side, is to control the courtroom. It's the power and the authority of the judge to keep everything under control, to make it more enjoyable for the members of the jury here.
Very good.
So those are the things I would talk to a new judge about. Again, be learned in the law. Be fair and impartial, be timely, and understand, and let the attorneys know what your courtroom procedures are.
Well, it seems as though each part of that involved letting the people know what your intentions are and what goes on beforehand, so that they'll understand things when they do happen. I think that's a very important aspect of it. There's an educational aspect of it.
Absolutely right. It's the way I feel. And, I just don't go into the dissertation on Lady Justice. My Lady Justice that I have was presented to me by a jury, unbeknownst to me. One day, a jury was dismissed, and they left this Lady Justice a present for me
Huh.
in the courtroom. And I wrote to all the necessary committees. I said, what am I going to do with it? I can't send it back. What am I going to do? They said, it's fine to keep it, and when you retire, present it to the law library, and that's what I
Yeah.
intend to do.
Okay.
But in this Lady Justice, she's standing on a law book, and beneath the law book are snakes.
Yeah.
So when when I explain to the jury what this means, I said the law books is the authority, is the knowledge of the court,
Yeah.
and that's why I'm judge of the law. And I say with the snakes, what they're doing is they're stamping out evil, because only truth will prevail in a jury trial
Yeah.
here in front of this jury here.
How about it?
And that's why I explain it to them. And I think hopefully it gives them some, at least in my mind,
Yeah.
hopefully they're enjoying their service as jurors, and hopefully looking forward to being back and next time we get that
Well,
little subpoena. in there.
I'm sure they are, really, to tell you the truth.
Yeah.
Is there anything else that you wanted to share with us today?
No, that's about it. And again, I take pride in the 51 plus years
Yes.
that I've been here. I've known you for a good number of years
Yeah,
also.
Yeah.
With your bow tie. I always remember that bow tie. And it's hard for me to believe that all this time has passed.
Yeah, and it's for
Yes.
me too.
Yeah.
But we're very lucky to have you.
Well, thank you. I appreciate that.
Thank you again.
Not at all. Thank you.
Judge Norman Ackerman.